Ethical Perspectives on the News is produced by the Interreligious Council of Linn County, which is solely responsible for its content. The views and opinions expressed on this program do not necessarily reflect those of the staff and management of KCRG TV9.
Welcome to Ethical Perspectives. I'm Bob Rush, and we have two outstanding panelists today to talk about the judiciary, the courts, the judges, who selects them, and what kind of system do we have in Iowa. Just by way of background, the majority of states elect state judges. Iowa is not in that category. And we can talk about the pros and cons of elected judges versus appointed judges. And with us today is the Honorable George Stigler, longtime Iowa District Court Judge, and Andrew Mertens. And I'm going to ask first the judge to share a little bit of background about himself.
Thank you, Mr. Rush. I'm an East Waterloo high school graduate in 1968. Grew up in Waterloo, attended the University of Northern Iowa, graduated in 1972, attended the University of Iowa College of Law. I became a judge in March of 1978 at the district associate court level and a district court judge in February of 1985. In my other life, I was also a JAG officer with the United States Army, and I put in 38 and a half years before I retired in 2010 from the military. I retired from my judgeship in 2020. And so I've got a little bit of a different perspective than perhaps most other individuals who serve as judges, or even some lawyers or so, because of the military background as well.
Thank you. Andrew, will you share your background, please?
Sure. I bring a non-lawyer perspective to this discussion. I am the Deputy Executive Director of an organization called the Iowa Association for Justice. It's formerly known as the Iowa Trial Lawyers Association. And so our organization represents trial attorneys who practice in the areas of workers' compensation, personal injury, criminal defense. There's all sorts of trial lawyers. The lawyers that our organization represents are the folks who represent real people going up against the more powerful entity. And another piece of background is I helped to co-found in 2010 and am still a board member of a coalition organization called Justice Not Politics. And that is an organization that is solely focused on preserving, protecting, and defending Iowa's judicial selection system. And when the occasion arises, defending judges within that system if they're attacked politically in a judicial retention election. So I've been involved with Justice Not Politics since really 2009. I believe we officially started in 2010, and I've been working in the legal community for lawyers through the Iowa Association for Justice since 2009 as well.
Thank you. One of the discoveries for me was working on a brief and learning that the first Iowa Constitution provided for appointment of judges by the state legislature. That didn't last very long, and the second Constitution came along and they shifted the responsibility for choosing Supreme Court justices to a direct vote of the people. And for many years, Iowa had elected judges until 1962, thereabouts. And then another constitutional amendment provided for returning to appointed judges. So let me just start out, Judge, you came through the appointed system as a state district court judge, is that right?
That's correct. In February of 1985, I was appointed to the district court bench by then Governor Terry Branstad. We applied and names were submitted out of that commission to the governor, and the governor made the final selection.
And Andrew, could you address how let's talk first about the State Judicial Nominating Commission, how that is currently structured?
Well, the selection process that we have in Iowa actually just turned 60 years old during the most recent primary elections. It was in the June primary in 1962 that Iowa voters officially added what we call merit selection process through a constitutional amendment. And so it was the 60th anniversary of that just during this last primary election. And as a way of interesting background, I think, our senior senator, Chuck Grassley, was actually in the legislature in 1959 and 1961 when this constitutional amendment first went through the process. So in order to amend the Constitution, a provision needs to pass through 2 consecutive legislatures and then get the blessing of the voters in an up or down vote. And in 2012, during an interview with the Cedar Rapids Gazette, actually, Chuck Grassley looked back fondly on that vote, and he said, I quote, "I'm the guy who voted in 1959 and 1961 for Iowa's present way of selecting judges. It was a very forward-thinking thing that we did 50 years ago," he said back in 2012. So I thought it's a fascinating bit of background about our current system that some of the legislative leaders today, while it has been around for 6 decades, some of our current legislative leaders were around and helped bless it through the process. Bob, you asked about the State Judicial Nominating Commission. From 1962 up until 2019, the State Judicial Nominating Commission, which chooses the slate of nominees that would become a Court of Appeals judge or a Supreme Court judge, is or was made up of 8 elected commissioners, folks elected by the lawyers of Iowa in an election process that is run by the judicial branch of Iowa.
And were there any others other than lawyers on that commission?
Yes, so there were 8 lawyers and there were 8 appointed members from the governor. And so those were appointed by the governor and approved by the Senate. And then there was one additional commissioner who was the senior most justice on the Supreme Court, who acted as chair of the commission. There was a slight change in 2019 that removed the judge from that state commission and replaced him with an additional appointee from the governor. So as the current system stands for appellate court judges, that's Court of Appeals and the state Supreme Court, the commission is made up of 9 appointed by the governor, 8 elected by lawyers, and they choose a chair from their group. And so all the applicants who put in for any opening on the Court of Appeals or Supreme Court is vetted by that group. They choose the top 3 for the Supreme Court and now top 5 for the Court of Appeals. And the governor makes the final choice. What is interesting about our process is that is not where it ends. Court of Appeals judges serve an 8-year term and district court judges serve a 6-year term. And the voters of Iowa have the final say over any judge that's appointed at the district court or Supreme Court or Court of Appeals level. Because after the governor makes their appointment, they serve for 1 year. And in the most recent election, after 1 full year, they get an up or down vote by the voters. And then after every term following that, so every 6 to 8 years. So voters still have the final say over judges.
Thank you. Judge, I'd like to ask you about the district nominating process. Could you give us a little background on how that works, please?
The district nominating commission works essentially in the same fashion that Mr. Mertens just indicated, except for one minor change, or one minor retention, I guess I shouldn't say change. With the appellate court procedure, the legislature removed the justice from the selection process. They did not make that change, though, with the district court proceedings. The presiding chair of the district court nominating commission is the senior active judge who is not the chief judge in that particular district. And so I was the senior judge for a good number of years, and I chaired a good number of the commissions that sent nominees down to the governor. The breakdown is essentially the same as Mr. Mertens has just indicated, an equal situation. Number of judges, or excuse me, the number of lawyers appointed by the Bar Association or selected by the Bar Association, with the number of civilians appointed by the governor. Everybody has an equal vote in terms of how the voting goes, and we select 2 names to go down to the governor, and the governor then makes up his or her selection out of those 2 nominees that have gone before him or her. In this case, the governor is Governor Reynolds, and so it would be her selection over the last, I guess, what is it, 2 terms that she has been governor of this state.
Some say that judges have too much influence in this nominating process. Would you speak to that, Judge?
I can only tell you, Mr. Rush, from my perspective, I chaired 9 different commissions that reported out 9 selected candidates by the governor. I never once attempted to exert any pressure on anybody or to influence or persuade anybody to do anything in terms of who they chose to support. I know there's been some issue up in the 2nd district, and I wish I could tell you what the resolution of that was, where there was a district judge who did chair the commission, and supposedly, I say supposedly because I don't know, supposedly did attempt to influence individuals into supporting the candidate that that particular judge chose to support. Mr. Mertens may or may not know what ultimately became of that. I should know, but unfortunately I don't know. But I can tell you, from my experience, we have always dealt with very honorable people, very committed people, people who want to report out the very best 2 candidates that they can. And I never once experienced anything that I thought to be untoward or anybody trying to influence anyone improperly. Certainly people support their candidates, and certainly people have strong feelings as to who they want to support and who they don't want to support. But I thought it was all in fair measure, and I thought it was all conducted in proper procedure and proper form. I never once saw anything that I would even remotely regard as being someone tipping the scales or someone trying to put undue pressure on other commissioners as to how those commissioners should cast their votes.
Andrew, did you witness any legislative criticism of judges having undue influence?
Frequently. That criticism comes from the same legislators who year in and year out try to remove what makes the Iowa's judicial selection process good. There are a number of legislators who want to see more politics in our system and want to see partisan politicians having more control over the commissions themselves. I think when you think about the benefit of a judge on the commission, it's I think pretty intuitive to imagine you have a commission of half lawyers, half civilians who are most often leaders in their community, folks who perhaps served in the legislature before or have served some major role in their community to the point where the governor would have selected them in the first place. And you have folks who have some motivations to see, a preferred candidate get through, and you have what is natural impulses of any group to jockey for position. You put a judge in the room, especially when that judge serves as chair, and you are curbing the influence of politics in the room almost immediately. The judge in the room, I think, can instinctively, you can understand how that can help to remove politics from the room and the process entirely. And beyond that, who better to answer questions about what makes a good judge than a senior judge in the district? They bring institutional knowledge not only of what an applicant should bring, but also what the district needs. One of the benefits of our judicial selection system is they can look at a pool of applicants and contemplate what the district or the state needs right now in the way of filling a seat on the bench. And they can make a choice from the applicants based on who is best positioned to fill that need. And the judge, especially at the district court level, can bring that perspective like nobody else can. So the criticisms that we hear from a minority of legislators, but a loud minority of legislators, is from the same faction of the legislature that wants to see the judicial selection process be replaced by a more political process and a more partisan process. Now, Judge Stigler brought up a really interesting example. It was up in Fort Dodge in 2B. The judge's name is Kurt Stobie, and he's still on the bench. And in my 12, 13 years being involved in this process, this is the first time I've ever seen a criticism of the way a judge has handled himself in the process of filling a seat on the bench. And immediately after the commission closed their process, they sent 2 names to the governor, and a handful of commissioners openly communicated to the governor that the judge had acted improperly. Now, just as Judge Stigler hinted to, these are allegations. I have no way of knowing the veracity of them, but they were credible allegations. And immediately the governor rejected the slate, asked the commission to go back to the drawing board, and the senior judge, Judge Drew, in that district replaced Judge Stobie on the commission immediately. He was removed from the process while the Judicial Qualifications Commission could investigate it, and he was replaced by another judge.
What was the outcome?
The outcome, which is so fascinating to me, is the commission, with a different judge in place, put forward the exact 2 names that the previous commission had put forward. So it didn't appear that the complaint was in the outcome. It was in the behavior of the judge. And he was quite literally immediately held accountable for it. He was publicly removed from his position. And this hit, every newspaper in the state, and was a pretty big piece of news. So it is certainly true that there is accountability for any allegations of misconduct by a judge. It didn't appear that this alleged misconduct affected the outcome, but it's fascinating that this was the first time in 13 years I've ever heard of, and perhaps in 60 years of the commission, I've ever heard of a judge taking any actions that commissioners would find, worthy of criticism.
Mr. Rush, may I address that at least in part?
Please.
I can only address in terms of what happened here in 1B, because I have no experience beyond 1B. I can tell you back when I first went on as on the commission to select judicial nominees, we had people who made what I considered to be honest mistakes. And by that, I mean, when we would have a female applicant for a judgeship come in, we had one or two instances where a commissioner would say, well, what does your husband think about this? Or if you're appointed a judge, who's going to look after your children? And those are inappropriate questions, as I'm sure everyone recognizes. And when I pointed that out to the commissioners who were asking those questions, they immediately complied. They, in all instances, apologized. They simply had made a mistake. The Supreme Court has training for new commissioners, and they are instructed as to what is appropriate and what is not appropriate in terms of things that they should address to applicants. And I don't think, other than back when, we've ever had that problem before or after. We've had people who make mistakes, but every mistake that I've ever seen, I think to be an honest mistake and committed by people who simply hadn't thought about what they were asking. And once they were informed, maybe you shouldn't ask that question, they immediately apologized, they immediately complied, and they immediately saw, well, maybe that wasn't the right thing to say to this applicant.
Mm-hmm. Thank you. I've read, Andrew, criticism from some saying, gee, these lawyers are all Democrats, dominated by Democrats. Could you speak to that, please?
Yes, that's in 2019 when the changes were made to the state judicial nominating commission that I just spoke about, that removed the judge from the commission and replaced that judge with an additional appointment by the governor. That was the conclusion of a session-long debate about the judicial selection process, where the legislature was, in their first attempts at the beginning of session, attempting to scrap the process as we know it and have nearly all commissioners selected by the legislative leadership and the governor. So, in other words, the most partisan politicians in the state of Iowa would be selecting almost the entirety of the commissions at every level. Thankfully, they didn't do that, but the discussion along the way led groups like Justice Not Politics to actually research the political makeup of the nominating commissions across the state of Iowa. And what we found, because we were trying to address this criticism, what we found is that the majority of the commissioners are registered Republicans. And about a third of the districts, the majority of the lawyers on the commissions were registered Republicans. So it was a perception about the commission based, I think, on perceptions that lawyers themselves are majority Democrats. That just wasn't true about our commission and probably isn't fair about the legal profession overall.
What the criticism about the Bar Association having too much control over the process?
Yes, I love taking on that criticism because there is a perception, I think, that the Bar Association themselves make the selection of the lawyer commissioners at the district and Supreme Court level, at the state commission level. And it's not true. In fact, the Bar Association has no direct role at all in the judicial selection process. You do not have to be a member of the Bar Association to vote in the commission elections. And other than encouraging their members to vote, the Bar Association has no involvement in the process. The election is run by the judicial branch in the same way that a county auditor runs their local county elections. And every single licensed attorney has the ability to vote in that election electronically. And the Bar Association themselves do not have any direct involvement in the process, let alone any sort of outsized involvement in the process.
Judge Stigler, in your many years involved in the judicial nominating process, did partisan politics ever surface in any dominant way when people were being considered for judges?
No. Mr. Rush, you hear rumors when you're on these commissions that this applicant is supposedly powerfully connected to the governor, or this applicant is not going to be favorably considered by the governor. It's been my experience, excuse me, it's been my experience that the politics on the local level really has nothing to do with the people that we send down to the governor. And to the best of my knowledge, I don't believe that the governors that we've had, Governor Branstad and Governor Reynolds, have really paid much attention to politics in their final selections. I've known individuals who went before the governors, both Governor Branstad and Governor Reynolds, who everyone said, well, this person is a powerfully connected Republican, and there's no question that the governor is going to select this individual, and it's a waste of time for the other applicant to even go down and interview. And surprisingly, in a lot of those cases, the person who was not supposedly well connected was selected by the governor. Let me tell you what I have experienced indirectly by virtue of going to Wisconsin and Illinois. I've got a family member who lives in a little town right outside of Milwaukee. And as you may know, Wisconsin elects their judges. And I have been over in Wisconsin on various occasions over the years during elections. And I am utterly amazed at the things that you see candidates for judgeships doing. For example, you will see some guy or some woman in a robe standing in front of a jail cell door, and they'll slam the jail cell door shut. And they'll say something to the general effect of, I'll lock them all up and nobody's going to get away with anything. And I'm thinking, if I were someone who was charged with a crime before that particular judge, I'd have a real concern as to whether I'm going to get a fair trial based upon nothing more than the way he or she campaigned and promised the public that everybody's going to get locked up and everybody's guilty. And I just don't see that as being proper. From a from a civil standpoint, I would have concerns if I were represented by an attorney who did not give to the presiding judge's campaign coffers, and doubly so if I found out that the opposing attorney made substantial contributions to the judge. I would have real concerns as to whether my lawyer representing me is going to get the same treatment that the opposing lawyer is going to get if the opposing attorney gave money to the presiding judge. I realistically can't see how people think that to be proper, but as you point out, that is the prevailing way that judges are selected in this country.
And Wisconsin, my research indicates they lead the country. $10 million spent on the last election of a Supreme Court justice. Gentlemen, this is a terrific conversation. I wish we had much more time, but we are at the end. Just a moment for any closing comment you might have. Andrew, you go first, please.
Sure. I would just point out to folks who are concerned about attempts to change our judicial selection process to insert more politics into it. There, almost every year, there are attempts by a certain faction of the legislature to politicize our selection process. And if this is something that you're interested in fighting back against, I'd encourage you to go to justicenotpolitics.org, where you can find out more information about a group that's looking to defend our process.
Thank you. Judge Stigler.
I would agree with Mr. Mertens. I think Iowa has an ideal selection process. I think Iowa has every right to be exceedingly proud of the way the system works and the nominees and the judges who come out of those nominations. I would not change a thing in terms of the way that Iowa selects judges. I think it works exceedingly well. It does not need to be changed.
Thank you so much, gentlemen, for joining us today. And thank you, viewers, for tuning in.